So welcome to NELA's 2020 webinar series. I'm Gabby. I'm one of NELA's webinar coordinators who will be hosting today's webinar. I'd like to start off by acknowledging the traditional custodians of the land on which I am on today, the Ngunnawal people, whose cultures and customs have nurtured and continue to nurture this land since the beginning of time. I pay my respects to elders past, present and emerging. So NELA is a national multidisciplinary member-based association focused on environmental law and sustainability. One of NELA's objectives is to provide a forum for and also assist in the discussion, consideration and advancement of environmental law among the legal profession and the wider community. So this year, perhaps more than any other year, has been an unprecedented one. The bushfire season of 2019-2020 was unlike any other we have seen. Unfortunately, it is just one example of future environmental challenges that we need to be ready to address. And it makes sense that we need future-proof environmental laws to help us respond to the challenges that lie ahead. As you know, our Federal Environment Act, the Environment Protection and Biodiversity Conservation Act, has undergone a statutory review this year led by Professor Graham Samuel. Last month, Professor Samuel provided his final report to the Minister for Environment, and we are awaiting its public release. Today, we are very fortunate to have Dr. Michelle Lim, a NELA board member and senior lecturer at Macquarie University, present a webinar about Professor Samuel's review through the lens of how anticipatory capacity might be embedded in law to address the unprecedented, interconnected human nature challenges of the Anthropocene.
Okay, thanks so much for coming, and thank you, Gabby, for acknowledging country. And I'm speaking to you here from the sovereign unceded lands of the Wadmata clan of the Darug Nation, and also pay my respects to elders past and present. And I also really want to thank Gabby and Leah, who have been so instrumental in making sure that the NELA webinar series continues to go ahead. Gabby's been moving house, also has had heaps of stuff on at work, so has Leah, and yet they're still rearranging things, making sure everything works, like emails, all that sort of thing. So thank you both so very, very much. I'd also like to thank our current president, Hannah Jareth, for all her support in all of this, and also our immediate past president, Jess Hamdor, who, even though has the lovely Olivia at home, only a few days old, is still checking up on everything is going smoothly. So thank you all very, very, very much. So we're here to discuss the EPBC Act review, which Gabby gave an excellent introduction to at the start. And as you know, the EPBC Act is Australia's key federal national environmental law. And it not only incorporates Australia's international obligations, but also dealing with matters of national environmental significance where greater coordination is required at the federal level. And as you would also know, Section 522A requires a review of this Act every 10 years. And that's what we're seeing here in terms of the Samuel review, a review to test whether the Act is meeting its objects and whether the operation of the Act is effective. And the response to this review has been immense. Even amid COVID, even when you had lots of NGOs still dealing with the impacts of the bushfires early in the year, there were 3,000 unique submissions to this review, as well as 26,000 largely identical submissions. So as you would know, it'd be campaigns where people aren't necessarily sure what they want to see change in the law, but definitely want to make their voices heard in terms of wanting to protect our unique places and species. And so in October, Graham Samuel submitted his review to the Parliament. And as you might imagine, I've been checking the EPBC Act review website probably as frequently, not quite as frequently as I was checking the updates of the US election, but we're dealing with the interim report here because, as Gabby mentioned, we haven't seen the final report. But the questions that we're discussing in terms of the EPBC Act and what is needed in terms of a reform, I think will largely still have the same level of, the broad issues we're discussing will have the same level of, I don't want to say significance, but they'll mean the same thing, even dealing with the interim report. So what are the key messages coming out of the review? One, that the Act's not only not good enough to address future challenges, it's not even good enough for dealing with current challenges. And therefore, fundamental reform is required. And that is a space that we'll be talking about a lot today. And I'm making the argument that if we want national environmental laws which are fit for purpose for the uncertainty and surprise which characterize the Anthropocene, we need a futures approach. We need to be able to anticipate the biophysical change and also be able to prepare with the future in mind. Importantly, we need to be able to think about what are the futures we actually want, because failing to do so will mean that we're focused on the really bad things that could happen, rather than thinking about, well, what's the direction we actually want for the environment, for humans and for the environment. And so putting it very much within a futures lens, arguing that we need to think about the role of law in terms of the futures we want. As an example, what sort of future do I want? I want a 2050 where we've averted the most serious threats of climate change. I want a future where we still have koalas, numbats, orange-bellied parrots, Wallamai pine. I want a future where Indigenous knowledge, law and governance is not only valued, but also elevated. A future which doesn't see development and the environment as two opposing things, but recognises that human development relies on a thriving environment. And importantly, a future where democratic processes and public participation is acknowledged and given effect to, and legal frameworks which support all of that. And it's that context that we have our discussion today. So if you're expecting today's conversation to be about devolution of powers or about national standards, it won't be. The EPBC Act, as you know, is a highly complex piece of legislation. So today's focus will be very broad. On the one hand, talking about how we can embed futures approaches within law, but very specific on the other, with a focus on biodiversity. And there are a range of issues that relate to biodiversity within the Act, but focusing on the threatened species and ecological communities component of that. So most of today will be asking the question about whether the listing processes under the Act are sufficient for now and for tomorrow, and also talking through some of the findings of the Samya review in relation to this specific issue. And towards the end of our discussion, I'll be talking about some of the ways in which we might be able to take a futures-focused approach to legal reform, and to end up with thinking about possible 2050s. I'll be actually taking us through a futures meditation, if you like. So stay tuned to see what that is all about. But to start with, what are futures? And more pointedly, what's with the S? Isn't talking about the future enough? Well, what futures studies do and what futures approaches suggest is back to some of the discussion we've been having already. It's not enough to think about one particular future. The surprise of global environmental change means that we need to anticipate a range of possible futures. Focusing on one possible future is not only futile, it's also inaccurate and doesn't inspire broader thinking about what future we actually want. So within future studies, within futures approaches, there's a range of different mechanisms for doing this. Scenario development is a key one that you're likely familiar with is likely the IPCC scenarios, which says if you've got this amount of carbon in the atmosphere, you can expect this degree of warming, etc., etc. So being able to anticipate what sort of impacts you're likely to see in the environment. And we'll come back to the IPCC scenarios in a little bit. Other methods include horizon scanning, looking at what's coming up on the horizon, and how to respond to those sorts of things. And another method is speculative fiction. That's what the final part of my presentation today will be about, is exploring what stories of the future might look like and how that might link to legal reform. So before I go on to the specifics of the Act and how fit for purpose they currently are, I'd like to take you to the evolution of futures thinking within the Samuel Review. So those of you who have submitted, have put in a submission to the review will likely remember question 7, which asks what additional future trends should the review think about. And you'll also be familiar with the background document, the discussion paper that came with that question. And as you can see on the screen, some of that background document said that the review will need to draw on the best available information to forecast the future operating context of the Act. Now, in Neela's submission to the review, and taking into account everything we've just been talking about, you can see we probably weren't that happy with this idea that we need to forecast a particular future. So COVID-19, for example, the bushfires, things that you can't really forecast, that you need to be able to anticipate. So I will quote you directly from our submission, which argued that crisis-driven and reactive nature of current laws are a key contributor to unprecedented ecological decline. This idea that we need to anticipate what's going to happen and not be reactive to legislate only once a disaster has occurred. So the characteristics of existing law are untenable given the increasing uncertainty and surprise manifesting within ecological systems. But planning in the context of uncertainty requires us to anticipate multiple possible futures while moving beyond grim projections. And we did specifically state that we were slightly uncomfortable with this idea of forecasting likely futures because attempts to forecast a singular future risk creating self-fulfilling prophecies as people orient their behaviour towards the future they think will eventuate. So work by Alina Bennett, for example, emphasises the need to work to examine desirable futures rather than just possible futures. And it's interesting and heartening to see in the interim report how much more of a futures approach has been incorporated. So not to suggest that that arose from the Neela submission alone, but the fact that multiple submissions were recognising the need for futuring, for a futures response in the Act. And I'll talk in a little bit about a really interesting recommendation from the review that reflects a new futures thinking within the Act. But for now, I'm going to move to the threatened species and listing threatened species and ecological communities, the listing issues under the current Act. So, as we discussed earlier, this is a federal piece of legislation. The environment is normally the issue of states, except largely for issues of matters of national environmental significance. And if an issue is a matter of national environmental significance, any action that will or is likely to have significant impact on that matter of national environmental significance needs at least to inquire whether an assessment or approval is needed under the Act. If you don't do that, significant penalties apply. So let's look now at action and what the matters of national environmental significance are, which will be familiar to many of you. I won't go through all of these, but this is just to say action means pretty much anything which is a verb. So if you're developing, if you're doing agriculture, if you're doing preparation work for construction, etc., action means a range of things that could have an impact on the environment. You don't need a review if it's going to have a positive impact. You don't need approval if it's going to have a positive impact, but where there is the possibility of adverse impacts, then if it's a matter of national environmental significance, you need approval from the minister. So what are matters of national environmental significance? Huge list here, and the biodiversity related ones here. We're going to focus on listed threatened species and communities because the listing approach and even the text of most of them is largely similar. For threatened species and communities, I'm not expecting you to read all of this, and it repeats itself over and over, essentially saying that a person must not take an action that has or will have a significant impact on species that are extinct in the wild, critically endangered, vulnerable, but also critically endangered communities and endangered communities. And we talked earlier about the significant penalties for that. The civil penalties are listed below. And 18A, reiterating the fact that if you take an action which results in significant impact on species or ecological communities, or even if it is likely to have a significant impact, then that is an offence. So the question now is, that's what the existing law is. Is it good enough to prevent Australia's horrible extinction, the continuation of Australia's horrible extinction record? As you know, we are first in the world for vertebrate extinctions, and also current extinction rates are higher than any other time in history. 3 vertebrates have gone extinct since 2014, including the Christmas Island skink and also Brambles Cay melomys, which was projected in the media as the first species to go extinct via climate change. Is the current EPBC Act good enough to prevent these things from continuing to occur? I think you know the answer, but let's see what the report said. So first of all, not only in relation to threatened species and ecological communities, but generally, the Act's not fit to address the matters of national environmental significance. Not only can it not stop the trajectory of environmental decline, it's not even good enough to stop current trajectories, let alone reverse them, and there's no planning for emerging threats at a landscape scale. And importantly, the review made the point that this is not a state of environment report, but they recognise what are the key drivers of biodiversity loss, including habitat destruction, climate change, invasive species, etc., etc. But our environment is so degraded, so impacted, that it has lost lots of the capacity to be able to respond to future threats. So the review found not only is the current Act not good enough, but it actually facilitates ongoing decline. So I've been talking quite a bit about the obsession with listing under the EPBC Act, listing vulnerable species, listing endangered species, listing ecological communities, which in itself is a good approach, the fact that they're looking at ecological communities rather than just an individual species approach. But there's this preoccupation with creating all these lists. That's not good enough, according to the review, but also according to the literature. So because of this emphasis on listing, there's this implication that the goal is to get all these lists done rather than actually do something about addressing the drivers of biodiversity loss, of making sure these species don't go further into extinction. So an example you can see is that there are 1,890 listed species, 84 listed communities. But there's only 719 recovery plans. So not even half of these threatened species have recovery plans in place, only 27 in place for ecological communities. But even if there was a recovery plan, even where there is a recovery plan for each of these species or ecological communities, you don't have to report on progress and there's no action to implement it. And a further critique of the current law is something that you hear time and time again in terms of the EPBC Act, the failure to deal with cumulative impacts. So an action can be approved for a discrete area, but doesn't take into account the fact of similar developments occurring right across the landscape, which in combination will have a significant impact. So on its own, probably not, but the Act lacks the facilities to deal with the combination of these impacts across the whole ecosystem. And therefore, the term death by 1,000 cuts is something that often goes hand in hand with any discussion of the EPBC Act. And the thread that keeps coming through the interim report, not only is the Act not good enough for the present, it's certainly not good enough for the future. So even though key threatening processes have been incorporated in the Act, that in itself is a really good thing. It's saying we're not just focusing on individual species or even ecological communities, we're looking at what some of the drivers of the impact on conservation status. But as you would expect, it's all listing again. So those same issues of listing coming up in terms of key threatening process. 21 have been listed. They include those you can see on the screen around rabbits, goats, and also feral species. But there's since 2014, no new key threatening process has been listed. So even inappropriate fire regimes aren't recognised as a key threatening process. And there's this huge tendency to focus on immediate threats rather than looking at what other key threats are emerging into the future. Even though, and the report finds, even though that we know if we act early on emerging threats, that's going to be so much more cost effective and lead to much better outcomes. And on this point, even though the interim report doesn't expressly say this, in many ways the precautionary principle, which is an objective of the Act, the precautionary principle would require us to anticipate what some of those future impacts are. And again, you see the limitations of the current listing process. Even if you do get, even if something is listed as a key threatening process, there's no statutory obligation to actually to do anything about it. So unless there's a threat abatement plan, then it's a list. It doesn't actually address, the Act doesn't require these key threatening processes to be ameliorated in any way. So I started talking earlier about the evolution of futures approaches within the Act. We've talked about how the Act has severe limitations for dealing with current and future threats. And we talked about how the initial discussion paper didn't take a futures approach, looking at multiple possible futures. But what is quite exciting is one of the recommendations of the report, which does really seem to be looking at a futures approach. But before I get onto that, I will couch this in the terms of the context within which this recommendation appears. So, as you will know, as we've discussed very briefly, there's a range of matters of national environmental significance that are currently considered under the Act. Time and time again, there's been suggestions that climate change needs to be included as a matter of national environmental significance. The Samuel Review concludes that no, we don't need climate change included as a matter of national environmental significance. I don't agree with that. I think and the reasons for it is it would create duplication in current processes, etc., etc. However, if we are going to implement our international responsibilities, if we are going to recognise the federal, national nature of climate change, it really should be one of the triggers under the Act. But that's an aside. So the Samuel Review says, no, we don't need a trigger. However, and this is where it gets exciting in a futures context, however, when thinking about mitigating the actions that we talked about earlier, when looking at whether an action is likely to have a significant impact, what's exciting is the report suggests that when considering the significant impact of an action, they consider it not only in terms of today, but also put it in the context of specified climate change scenarios. So we started talking at the beginning about the different types of scenario processes, including the IPCC type scenarios of the impacts of climate change. So what the exciting suggestion of the review is that we take that into account when approving development proposals, approving actions. The consideration of significant impact takes longer term climate processes into the future into account, not just the threat of today. So I think that's a really exciting development. However, and these are the words of my friend and colleague who we've been collaborating in these futures issues about, Karina says, our futures are about so much more than carbon. So even though I've just said how exciting the recommendation of taking climate scenarios into account is, even though how that's really exciting, in a futures context, it probably doesn't do enough. Not only are our futures about so much more than how much part per million of carbon is going to lead to how much warming, these sorts of technocratic approaches do not engage with emotions of fear, grief, and hope. That we need to think about what are the desirable futures we want, what sort of 2050 that we want. And so moving on to what a futures-focused nature law reform might look like, picking up on this idea that it's about so much more than carbon, the overarching question is, how do we design law which anticipates the changes of the Anthropocene so it's fit for purpose today and also 30 years down the track? And first of all, we need to design with multiple possible futures in mind, but ultimately with a desirable 2050 in mind. What do we want in the future? How is law going to help us to get there? And drawing on what we've already started to discuss, how do we anticipate and address the key drivers of biodiversity loss? We spent a bit of time talking about an action under the EPBC Act. It's important that we don't just look at a particular action, a particular development proposal, but also address those drivers of biodiversity loss, such as unsustainable consumption and production, such as climate change, such as invasive species, thinking about all of those and their contribution to biodiversity loss, in addition to actions which are dealt with under the Act. And current law, it's not just a criticism of Australian law, but current environmental law has a very static approach. This idea that our protected areas are fit for purpose today, so they will also be similarly fit for purpose tomorrow. Climate change means that it's not. You can't set and forget. We need more anticipatory and adaptive approaches to deal with the huge and, in many ways, unpredictable changes of our futures. And importantly, we need to deal with cumulative impacts, not just, even if the Act dealt with cumulative impacts of today, that would be great, but we need to be thinking about those cumulative impacts over time and into the future, and particularly in a federal Act, thinking about those cumulative impacts across state boundaries. And importantly, we need to think about the knowledges, law and governance approaches which have cared for this land since the beginning of time, to elevate Indigenous approaches, thinking about the past and leading that into the future. Another thing that's really important, in some ways you could say it's important anyhow, not just in a futures context, but definitely in a futures context, we need much more resourcing of current environmental protections. Even if we just funded and implemented everything which is already there, we'd be way ahead of where we currently are in terms of biodiversity loss. And finally, and this is going to lead into the final part of today's discussion, finally, we need to find imaginative ways in which to collectively dream up the futures we want. So at the start of today's discussion, I talked about the future I wanted. You might agree with some of that, and you might disagree with other parts of the 2050 which I wanted. The difficult bit is thinking about how we design futures in a collective way, and importantly, who gets a say in thinking about what the future might look like, and also who probably shouldn't have a say in those discussions. Gina Reinhardt, etc. So in order to start us thinking about the futures we want, I'm going to end by taking us through a futures meditation, which is probably slightly different to anything you've done in other legal presentations, but it's 2020, so everything goes. These meditations take from our paper, our piece in the conversation. It imagines a range of possible futures for 2050. None of them are particularly desirable. Each of them is possible. So when you're listening through these futures that we've come up with, I'd encourage you to think about, what do you like in these futures? What don't you like? How does that help you think about the 2050 that you want? And I'm thankful for everyone who has their video on. It's been really good to see your support as I've been talking, not just to a computer. But for now, I'm actually going to turn off my video. I'm going to stop sharing screen. I'm going to turn off my video, and I encourage you to do the same. And just close your eyes if you like. Just listen to what each of these futures are, and think about what sort of future you might like. So, we're in the year 2050. And this is the first of a range of possible futures. 1, basic needs. You sit in a communal kitchen as you sip your low food mile oat latte. You watch the news through a holographic vidcast floating beside you. Governments and societies have prioritised equality and social welfare over consumerism and industrialisation. The myth of trickle-down economics has been exposed. Countries have turned to localised food production, reduced consumption, trade and travel have caused carbon emissions to flatline. But it may be too little, too late. Your vidcast tells of winter bushfires in Tasmania and water shortages in all Australian capital cities. You wonder if more spending on technological innovation might have averted these crises. Nature, considered useful, is doing well. Brisbane's restored mangroves are flourishing. The city no longer floods, even with sea level rise. But there is little funding to protect wildlife, and iconic species such as mountain pygmy possums are extinct. Now to our second possible future in 2050, wildlife rules. You wake up with lab-engineered coffee, then eat breakfast cereal grown at an indoor climate-controlled farm. You log on to the annual Australasian Conservation Summit. A virtual reality tour takes you to the Great Western Sydney Reserve. There, koalas shipped from Kangaroo Island brought local populations back from the brink. Data from their geolocation tags confirm they now occur across their historic range. You welcome preservation of this iconic species, but the region's traditional Darug clans were not consulted in setting up the reserve. You wonder why they continue to be excluded from walking the country of their ancestors. Australia has a significant wildlife conservation sector supported by the military, which has created many green jobs. But society as a whole is disconnected from nature. Most people now experience it via zoos and tree museums. Some wildlife species may be thriving, but the Great Barrier Reef isn't. Global heating is worsening and the burning of fossil fuels continues. Successive years of extreme bleaching has left the reef all but decimated. And on to our final of three possible 2050s. This one is called Climate First. You munch breakfast from locally farmed oats. As you inject your carbon-neutral caffeine hit into an arm vein, you feel a wave of nostalgia for a good old long black in a mug. Thanks to radical technological solutions, the most catastrophic climate impacts have been averted. Global governance is now dominated by the ideologies of the Radical Climate Action Alliance. In 2021, environmental and human rights treaties were revoked in favour of the Climate First Charter. Your Unity BCI, brain-computer implant, receives drone footage from the Alliance. It shows Australia's red centre covered in solar farms, agricultural lands swamped by biofuel crops, and South Australia's Flinders Ranges dotted with nuclear reactors. The clip closes with images of carbon-capturing radiata pines dominating vast landscapes of the Adani and Rocky Hill carbon sanctuaries. You wonder what it's like inside. Carbon sanctuaries are closed to all except the carbon ranges. Even traditional owners are excluded from the country they sustain for millennia. Meanwhile, corporations benefit from green energy ventures while social inequality rises. The Great Barrier Reef no longer suffers from summer bleaching events, but indiscriminately placed wind farms have brought the swift parrot and grey-headed flying fox almost to extinction. So, as we argue, and feel free to also turn on your video now, as we argue in our conversation piece, none of these futures are inevitable. but exploring the logical conclusions of present-day attitudes and decisions can prompt us to ask, what futures do we want? And so, in conclusion, I have 3 points. The first is that our futures are not fixed. We might not like what is possible, but at the same time, there remains a window of opportunity to change current trajectories. Secondly, neither the EPBC Act review or the shenanigans or the bill that is currently going through Parliament are the endpoint. And finally, we need to think about what futures we collectively, what futures we want, and how legal change today will help us along the road to getting there. Thank you.
Thanks, Michelle, for your presentation about futures-proof environmental law, and also for the environmental meditation today. I haven't ever really done anything like that before, and I know that I find thinking about some possible scenarios like coral bleaching and significant loss of biodiversity to be really difficult to think about. Particularly when we hear about these kinds of issues, so much destruction and so many power imbalances in decision making on a day-to-day basis. You've also reminded me that thinking about the future that we want as a society and a community is a really useful and important tool for thinking about how we might change our laws for a future that we want. So thank you, Michelle. I'll now open up to questions if anybody has any. You might want to raise a hand or put some questions in the chat group. If anybody has any. Don't be shy.
Actually, while we're waiting for people to think about questions, another key thing that has been the main discussion around the EPBC Act is this discussion about standards. So I know I said I wouldn't be talking about it here, but just when you're thinking about questions, another thing that I don't necessarily agree with in terms of the Samuel Review is the framing of standards for threatened species and ecological communities. Its reference to this idea of no net loss, to me, is uncomfortable. It suggests that different patches of biodiversity can easily be substituted. And I fear the risk of no net loss, which is also being discussed very much in terms of the post-2020 framework of the Convention on Biological Diversity, is a risky way of allowing biodiversity to be destroyed under the guise of being able to be substituted elsewhere. So I'll take that as a comment. But I can see that there's questions coming through in the chat box.
So we have a question from Hannah about how many submissions to the Samuel Review aren't accessible on the review website, and whether anyone has an idea of when we might be able to see the full report, when that will be made publicly accessible. So my understanding is that the report needs to be put to both Houses of Parliament within 15 days, and then it will be made, and then it is a matter for government to make it publicly accessible. That is all we have in terms of an indication about timing. So hopefully I hope that we'll be able to get it by the end of the year, but you never know.
Yeah, and something I learnt, so we thought, 20th of November, it's meant to be June in October, 20th of November is a good time for having the webinar because, it'll be out by then. But 15 days means, and I learned through this process, means 15 sitting days. So even though the report is completed, it's 15 sitting days before it actually comes out. And to Hannah's question of how many submissions are not accessible on the website, great question, Hannah. I didn't even know that some weren't available. So can't answer it, but a good question. A good question in terms of, is it the fact that even though people have put so much effort into these submissions, they're not being made publicly accessible? And I don't know, is the answer.
I have a question, Gabby.
Yeah.
Hey, by the way. Thanks, Michelle. I was wondering if you'd thought through the process of what it might look like taking, I guess, this visioning process to communities and how participatory design kind of these futures might work on a kind of a local or community scale.
Yeah, that's an excellent question, and I think that's really goes to my point of, the EPBC Act review is only the starting point. We need to then harness all this interest and effort that's gone into responding to the review and going out to communities in series of workshops, perhaps having surveys beforehand, asking people what are the key values that they want, and then getting people from across the community together in these workshops. And the way I would see it being done is you have a graphic illustrator as part of the process, drawing, and so it's a process where people are discussing where the trade-offs potentially are, where there's shared values, identifying where those shared values are, and actually illustrating what the common future might look like. So very much action research, if you like, in terms of people owning the process, and that's exactly how I see these processes happening both at the local level, but also within state government, within national government, having national stakeholders also going through the same process, but importantly also at the local community level. And on that note, a shout out to South Australian government who, even in times of COVID, have done a similar sort of process via Zoom, but that's where I see these sorts of approaches needing to go to get to the sorts of things that we've been discussing. So great question.
Any other questions? Okay, well, we might wrap it up there. Got 5 minutes to go, but maybe we'll have a little early mark. Thank you, everybody, for attending, and to Michelle for your presentation, and also to Leah Hilton-Camp, who assisted us with putting the flyer and the worked out the logistics for Zoom for this webinar. So thank you, Leah, as well. If anybody is interested, we are also holding another talk about Indigenous knowledge in environmental decision making next week or the week after. The details are on NELA's website, and we've got a great panel of speakers chaired by Dr. Judith Preston, also from Macquarie University, which looks to be a really, really great panel discussion. So if anybody's interested, please head to the NELA website for more details, and hopefully we'll see you there as well. Thanks, everybody. Bye.
Thank you.